So the state appears to be requesting the full gambit in here. Is the state requesting this to be a final or temporary order?
State is requesting final orders at this time.
All right, folks, I'm gonna go ahead and get you both sworn in, and and of course, you have to answer the questions of the state. You have to answer them truthfully and to the best of your recollection and knowledge. At the end of the hearing, I'll allow y'all to make a closing statement or closing argument as far as your case is concerned, because you technically represent yourselves. But what we're looking at here, folks, is the state's requesting everything that the state's entitled to, and parties are entitled, both parties are entitled to under the Texas Family Code. The state is asking me to set up custody, visitation, child support, all based on what the Family Code does as far as requirements. And in addition to that, the state is requesting back child support or retroactive child support, which under the Texas Family Code, the court has the absolute right to go back to for the last a minimum of the last 4 years, giving any and all credit for any funds paid to the custodial party by the non-custodial party. But again, the law is the court is to look at the last 4 years and could order that amount, and that amounts to be reduced to a judgment with payments to go along to repay that, to go along with the regular child support, and sometimes that can get a little substantial. So if this looks like that may be the case in this matter, the court will reserve the right to make this a temporary order to allow the non-custodial party the opportunity to actually seek legal counsel, because again, this could be substantial, and I don't know what it is at this point. But I just did one earlier today where the back child support was $18,000 and some change. So again, it is what it is. But at this time, I'm going to need both of you. Ma'am, you're muted. Please unmute yourself, and sir, turn the video and unmute yourself, and both please raise your right hands.
You're not gonna want me to unmute myself right now. I'd rather just no.
I beg your pardon?
I'm not gonna lie to you. I don't want to be unmuted right now. I'll turn my video off, but I'm not unmuting myself. Please, I'm just want to keep my mouth closed.
All right, here's the deal, sir. You can keep your mouth closed, but if I'm going to go hear one side, that's the side I've got to go with. So that may not be to your advantage, sir. So, but this is a free country, and you can help yourself or sabotage yourself, whichever you think is best for yourself, sir. But at this time, the court is looking at going ahead and proceeding, and if you don't swear, let me swear you in, sir, then you cannot testify. You understand that?
From the very first words, the tension is already undeniable.
All right, then we're proceeding in default at this time. And ma'am, raise your other hand.
This
right hand.
This right one?
Yeah, your right hand.
Wait, this is my right hand.
Don't worry. I know that by now for sure after 20 years.
Yeah, I'm like, woo.
This camera's got that inverted thing working. But ma'am, do you
Yes.
swear or affirm me testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, then the court will note for the record, and obviously the record will reflect that the non-custodial party was present, decided he didn't want to testify, and left the building. So at this time, I'm gonna go ahead and let the state call their witness and we'll proceed to final at this time. Thank you.
Thank you, Your Honor. Before I begin, I ask the court to take judicial notice of that those two acknowledgments of paternity, states A and B, and I ask that those be admitted.
All right, ma'am. I'm with the state. Yes, your acknowledgement of paternities for your two children in this matter. Is there any objection to court allowing these in evidence at this time?
I'm sorry, I didn't hear that last part.
The state is asking me. The state is requesting I admit your acknowledgement of paternity for your children into evidence at this time. That you and the father signed off on. All right. Yeah. All right, states going to be admitted. I'll ask the state to attach a copy of those to the final order of this matter, since that's got to circulate back through me. And I just want to dot my I's and cross my T's on that one. And you may proceed at this time. Thank you.
Thank you, Your Honor. At this time, I call Ms. Smith as my first witness.
Okay. All right, Ms. Smith, state your full name for the record.
My name is Candace Tanisha Smith.
All right, thank you very much. You may proceed with your questioning.
Thank you, Your Honor. What are the names of the children before the court today, Ms. Smith?
Their names are Winter and Summer Young Smith.
And what are their dates of birth?
May 3rd, 2023.
And are they twins?
Yes, fraternal.
Who do the children live with?
Me. Myself. Mhm.
Did you and Mr. Young live together after the children were born?
Yes, for a short time, up until about March of 2024.
And at
So they're
March of
about 2
20,
months. Mhm.
okay. At March of 2024, did you and Mr. Young split for good, or did y'all end up living together again after March of 2024?
We broke up, and he ended up coming back again around September, August of 2024. And
And did,
then,
Mhm.
I'm sorry. Mhm.
Oh,
And
and
then he
then
left again.
after, when did he leave again?
So he left again December. So after he came back in August or September, he left again in December due to us having an issue around then.
How often does Mr. Young visit with the children?
He hasn't seen the girls since December, like physically. He hasn't seen them at all.
When he did see them during those times that y'all were separated, how long did he normally have the children for?
Oh, each time he left, he didn't contact. So each time of last year that he left, he didn't see the girls or contact us until he was ready to come back.
Has he ever had an overnight visit alone with the children?
Without me
The tension rises as shocking claims leave everyone stunned. You can almost feel the air shift as the case takes a sharp turn.
being home,
Yes.
no, not by himself.
Do you have any safety concerns about the children visiting with Mr. Young?
Yes, I do.
What are those
We
safety?
were well, because we were also investigated by CPS, I feel like he is not going to feed the girls, and it's undetermined whether he's going to have an episode on them and like yell at them, because that's what he's known for, yelling at children. So yes, that's my safety concerns, is that he's not going to feed them properly, and he's going to be doing stuff around them that's not okay.
You said there was a CPS investigation, excuse me. Is that
Yes.
still open or is that closed?
It's closed, but they listed all 3 children, because I do have now a 13-year-old boy who's been in the home as well. So they listed all 3 children, and he was found reason to believe, and I was unable to determine, meaning I was fit and he was unfit.
And did you ever have an open CPS court case, or was it just a services case?
It was not an open court case. It was just, we were investigated for 30 days, and they provided this document type of thing.
Okay,
And
but
then
you
she
never had to
also,
go in front of a judge?
no, I never had to go in front of a judge for this.
What would you like the court to order with respect to visits between the children and Mr. Young?
All right, ma'am, here's the deal. The norm is if I'm concerned about you know, problems, then the visits are usually somewhere between 4 and 8 hours, depending on I usually restrict those to Saturdays or a Sunday, so either 9 to 5 or 12 noon to 4. That way, you can feed them before they leave, and they'll be back in 4 hours. Yeah, but that's the norm. If dad's going to do them by himself, if you're looking at doing as some type of visitation with you being present, then it is that 4 hours from 12 to 4. And usually, unfortunately, it's your residence, but it's one of the two. It needs to either be with you or by himself. So, what are you requesting the court to do under those circumstances, ma'am?
I don't really feel comfortable with him around the girls without me being there.
And how old are
Because
they
my
now?
children they just turned 2, but they're also not speaking. Like, I have them in speech therapy, and they're about to
Okay.
be tested
Okay.
for autism. So I don't
All
feel
right.
comfortable, because they're on the spectrum. They already look like they're on the spectrum. So I don't feel comfortable without being around them.
All right, here's the deal. Okay, here's the deal, ma'am. Then the norm is under those circumstances, the first, third, and fifth Saturdays of the month from 1 to 5. And like I said, it can be with you or your designated agent to do it, but it needs to be very specific because dad does have his rights, okay?
Mm-hmm.
All right. So if I'm looking at the first, third, and fifth Saturdays of the month from 1 o'clock to 5 o'clock with either you being present or your designated agent, is there a particular spot that would work for you, ma'am? And again, outdoors doesn't work. Okay, the weather gets hot, the weather gets cold, so I need an indoor location. And so, what are you requesting, ma'am?
Again, my home is fine.
Okay.
And I'll be the person because I don't have relatives that lives close.
Okay.
I can always just call the police and do a civil standby. I've
All right.
did it before. So I will definitely do that if I don't feel
All right,
safe
then.
then.
All right, then, ma'am. I'm looking at the first, third, and fifth Saturdays of the month from 1 o'clock to 5 o'clock upon him giving you at least 72 hours advance notice that he wants to see his children for his visitation. Okay. So in other words, by Wednesday evening, he has to let you know he's going to be there on Saturday. Or do you prefer Sunday?
I prefer Sundays, but I have a question because
Yes,
I also
ma'am.
stated that next year I'll be moving like out of state because I have to take care of my elderly mother who lives like Midwest.
Yo, that's
So
the
how would this
no, I only could take a snapshot in time, and for right now, that's the only visitation I would order. If that needed to be modified, then it had to be modified.
All right, guys, watch closely as the judge shuts down a bold outburst. This moment changes the energy in the room instantly.
But for right now, ma'am, he would have to come to you wherever you
Okay.
are, and the court could always order electronic visits also as part of that package. But for right now, and of course, y'all can agree to anything you want, but
Okay.
yeah, based on his behavior here today, that might be a little difficult. So at
Okay.
this time, ma'am, I'm looking at the first, third, and fifth Sundays from 1 o'clock to 5 o'clock, first, third, and fifth. Every couple of months, there's a fifth Sunday, so it's usually just 2 Sundays a month. But he's got to give you at least 72 hours advance notice that he's going to come to the visit. Do you normally do y'all communicate via text, or how do y'all normally communicate with each other?
Um I'm always on the block list, but
All right, here's the deal,
he'll
ma'am.
video chat me. I guess he'll video chat. I don't block him, but he blocks me. So it is video chats or he'll send a random text. Like
Okay, here's
that's
the deal, ma'am. I'm gonna put y'all into a free parroting app. It's free. It's called App Close.
oh, let me write that down.
Right, APPCLOSE. It's the #1 parroting app because it's free. But
Okay.
it requires you to set up an account, and then
Uh-huh.
you forward him that how to get into that account. And I'm going to order that all communication going forward needs to be by App Close, because App Close has texting function, it has FaceTime function, it has everything. Okay, so if he
Awesome.
doesn't do it, he doesn't do it. Okay, but it's left up to, I'm ordering him that if he wants to set up his visitation, it's got to be through App Close. All right.
Okay.
That way, because if I need to, I can appoint a lawyer to represent the girls, and the lawyer can get a copy of everything from App Close that you two discuss, everything what happened. So we won't get into that he said, she said stuff. All right.
Great.
I prefer to do this on on a parenting app other than on your cell phones or on Facebook or whatever. All right. So yeah, we'll just go that route for right now. And I'll go
Okay.
ahead and let the state proceed with questioning. You may proceed at this time now, Ms. Haley. Thank you.
Thank you, Your Honor. And excuse me for I had a bit of a cough a moment ago, so thank you for your patience there. Has there been any family violence between you and Mr. Young?
Yes.
What
In December.
happened in December?
Okay. A situation happened in December where I was assaulted at the store and then I assaulted him back and I ended up arrested and that's why CPS was called because I told them I do not feel comfortable with him in the home with the children alone. Yes.
Right.
You
Go ahead. Has either of you ever been convicted of family violence, ma'am, by a court of law?
Nope. I haven't. Nope. They dropped
Oh,
everything for me. Mhm.
all right. Thank you.
Thank
Has
you.
he?
I don't know what's going on with him. Like I said, I haven't really talked to him. So
Okay. All right. But you
anything
haven't been called to
besides
testify or anything like that, right?
no, I haven't because they dropped everything. I have a no bill.
All right. Thank you. All right. You may
Thank you.
proceed, Ms. Haley.
Thank you, Your Honor. You just let the court know that you're okay with visits being at your home. I just want to confirm, do you have any safety concerns regarding having your address in the court order?
He knows where I live. I live in the same place. So as of right now, I'm okay with it because he already knows where I live.
Okay, here's the deal, man. Going forward, if you move, you get.
Witness testimony flips the entire courtroom upside down. The reactions tell you just how unexpected this reveal really was.
You gotta let him know where you moved to if it's in there. Because he's
Mm.
got to come visit at your residence. 'Cause that's
You're
what
right.
you
He
just
does have to
did.
come.
Yes, ma'am.
I got you now.
Yeah.
I'm sorry about the facial expressions. I got you.
That's okay. All right, thank
I'm
you.
okay with it. Yeah.
All right, thank you, ma'am.
Thank you, Judge. How is the child covered for health insurance? Excuse me.
I applied for Medicaid.
Are they currently
So the children have Medicaid, the state insurance.
okay?
Do you have private health insurance available for the kids through any source?
No, ma'am.
Since you, or during the times that you and Mr. Young were separated, did he provide any financial compensation to help support for the children?
One time, $15.
Did he ever purchase any goods or anything for the children?
No,
Do
he
you
did
know-
not. Mm-mm.
During the year of 2024, when y'all were separated, do you know where he worked?
When we were separated, he just told me he was working. The first time, he just told me he was in Missouri working for his cousin. That's about it. After that, no, everything's pretty much a secret now.
Do you know how much he earned when he was working with his cousin during that time?
No, that was the first breakup, so no.
Do you know where he's currently working?
Oh no. I just know when he calls and he speaks to girls, I know he has some type of mask or something on, so it looked like it may be construction or something, a warehouse.
Does he have any other minor children other than the two they all have together?
Yes, he does. He has a son, Aiden.
Do you know how old the child is?
I think Aiden is 5 or 6, or he's about to be 6. So the girl are 2. Yeah, so I think he's about to be 6 in September.
Has Mr. Young ever been found to be disabled by the Social Security Administration, as far as you know?
No.
Is there anything that would prevent him from working at least a full-time job at minimum wage?
No.
That's the witness, Your Honor. Thank you.
All right, ma'am. Does he have a normal profession he does? Does he work construction? Does he work building houses? The mechanic? Does he do anything? While y'all were together, did he do anything like that?
That was the issue. He kept like getting fast food jobs when he is a brick mason, but the most jobs he would have is like moving jobs, like to help people move furniture or like Ashley's or things like that. And then he would work it, and then it's like either the work ethics wasn't there and he would be let go, or that was the issue. It was basically constant jobs going back and forth.
Okay.
Yeah.
All right, got it then. All right then, ma'am. Is there, well, I'm getting ready to go ahead and now let's the state in the closing to tell the court exactly what the state's asking for as far as child support, cash medical support, retroactive child support. I'm already, and I'll make the decision on what type of conservatorship to order, and obviously I'm going to do the visitation package as I already stated. So at this time, I'll let the state go ahead and make that statement. And then at the end of after I make my rulings, ma'am, you'll have the opportunity to tell the court if there's anything else you want me to try to do here today. Thank you.
Thank you, Your Honor. If I can have just one moment to get a good retroactive support calculation, it shouldn't take me very long.
Not a problem. I'll pause the recording. Thank you.
Thank you, Your Honor. For the retroactive support calculation, state has a recommended judgment of $3,465.80. That is considering the time while the children lived with their father. So it does include that. It does not include that time because he was providing direct support during that time. and it's using the guidelines of minimum wage of $2.60 a month plus interest for that time. State has a recommended current support amount that is based on the guidelines of $250 a month for current support for child support and $50 a month for current medical support. State asks that begin to be paid beginning July 1st, 2025. State also has a retroactive payment on that amount, also asking that begin July 1st, 2025 of $70 a month. And state would ask that Ms. Smith continue the children on the government health plan until private health insurance becomes available, and that Mr. Young pay any court costs as billed, if they are billed. We would ask that he have a year to pay those off. Thank you, Judge.
All right, ma'am, I'm looking at going ahead and naming you sole managing conservator of these children. That the reason to believe testimony from you uncontroverted is by CPS is sufficient for me to have concerns about naming this gentleman a joint managing. So I'm going to name you a sole managing conservator, name him a possessory conservator. But for right now, the only rights I'm going to give him.
The defense swings hard in this moment, fighting to shift the narrative. Every word now feels like a gamble with everything on the line.
Are the limited rights to have the visitation as ordered by as I'm getting ready to order the possession order. I'm getting ready to order, and the that's pretty much what I'm going to give him at this point, and the obligation to pay the child support. So what there's usually a list available. He can go to schools, he can go to doctor's appointments, all those kind of things. But I'm not going to order those until further on the court until he comes back and makes those requests directly of the court. I'm going to go ahead and order him to pay the child support amount as requested by the state. The cash medical amount is requested by the state. I'm going to go ahead and order that he repay the retroactive child support at the amount the state also requesting that's $70 a month. I am going to go ahead and order he be responsible for court costs if the county bills it, and I'll give him until the 30th day of June 2026 to make that payment, to pay that off if he is so billed. And I think I just covered everything. Is there anything I left out on this one, Ms. Haley?
No, Your Honor, I believe that's it. Thank you.
And man, like I said, I'm going to go ahead and order visitation, as I said earlier, the first 35th Sundays of the month from 1 to 5, upon giving you at least 72 hours advance notice. And that moves to Thursday, ma'am, instead of Wednesday, like I said earlier, since we moved it to kick to the day. And I'm going to go ahead and order you to download App Close and put it on your phone and send it to his last known phone number. If he's got you blocked, then that's fine. But as long as you can show that you did what you're supposed to do, you're covered. All right. And of course, you could agree to you and he can agree to anything else you want to as far as that. But the court ordered is that he does get to see them those 2 Sundays, at least those minimum of 2 Sundays a month. All right.
Yes, sir. Yes, sir.
All right. All right. So at this time, ma'am, do you have any questions or anything else you're asking me to do here on this order?
No, that was it.
All right. All right, then, Ms. Haley, I'm gonna go ahead and make this the final order of the court. I'll ask you to prepare that, circulate it to the mom and let her go ahead and review it and sign off on it and I'll sign off on it and we'll get this one taken care of. Is there anything else that you need at this time of okay, Ms. Smith at this time? Thank you.
No, that's all. Thank you.
All right. Anything else, Ms. Haley, did you need Ms. Smith for at this time?
No, Your Honor. Thank you.
All right, then, Ms. Smith, I'm gonna go ahead and let you go. And it's like I said, you should be getting something by DocuSign from the state. Signing off on it doesn't mean you agree with it. It just means that that's what those are ordered the court. And like I said, if you don't, then it'll be eventually sent to me, and I'll sign off on it based on my pleadings here. But ma'am, until further order of this court, this is the court that has continuing jurisdiction in your case. So long as you live in Comanche County or the state of Texas, we have jurisdiction. Once you live somewhere else for 6 months, then you can take that up there, but maybe. But for right now, like I said, Comanche County is the place to go for child support changes, visitation changes, anything like that has to be done through the district court judge or myself. I know that's a lot of legal mumbo jumbo. That's just saying that we can change stuff in the future until the girls reach 18 years of age, okay, and graduate from high school. All right.
Thank you.
All right. Thank you. All right. Thank you both. Thank you very much. And we're off the record, and you're both free to go. Thank you.
And here it is, the verdict moment that lands heavy in the room. Silence falls as reality sinks in, closing the case powerfully.